Advanced Taxation, Chapter 2, Objections and Appeals. Contents: 1. Purpose. 2. Objection and appeal procedures. 3. Establishment of tax appeal tribunals. 4. Jurisdiction of the tribunal. 5. Criminal prosecution. 6. Appeals to the tribunal. 7. Appeal to the Federal High Court. 8. Right to legal representation. 9. Further appeal to the Court of Appeal. 10. Chapter review. 11. Worked examples. Objections and appeal. Subtopic 2.0. Purpose. After studying this chapter, readers should be able to A. Know the composition and jurisdiction of tax appeal tribunal. B. Understand what constitutes an appeal. Understand what constitutes an appeal. C. Know the procedure for raising objection to tax assessment. D. Know the procedure for the hearing of appeals. E. Know the procedure to be followed for further appeals to the High Court or Court of Appeal. And F. Know taxpayer rights in a dispute. Section 2.1. Objection and appeal procedure. A. Where a taxpayer receives a notice of assessment, he either agrees with it or he is aggrieved. Where he agrees with the assessment, the position of the law is that the tax must be remitted within the statutory time limit of 60 days from the date of receipt of the assessment. B. Where he is aggrieved, however, he is expected to raise a notice of objection. The notice of objection must be valid for it to have any effect. For a notice of objection to be valid, such a notice must have been made in writing, must have been made within 30 days of the receipt of the notice of assessment, must contain the grounds of objection. C. Upon the receipt of the valid notice of objection, the relevant tax authority will examine the grounds of objection to determine their validity. Where the grounds are found to be valid, the tax consultant will be where the grounds are found to be valid, the tax computation will be reviewed and a revised or amended assessment raised. Payment will be based on the revised amendment. D. Where the relevant tax authority believes that there is no merit in the notice of objection, then a notice of refusal to amend would be sent to the taxpayer. E. The taxpayer, if aggrieved by the notice of refusal to amend, should file a notice of appeal to the Tax Appeal Tribunal within 30 days of the receipt of the notice of refusal to amend. Information required in a valid notice of appeal. For a notice of appeal to be valid, the following information must be included. 1. The tax file number. 2. The relevant year of assessment. 3. The date the notice of refusal to amend was received. 4. The assessable profits for the year of assessment being disputed. 5. The taxable profit being disputed. 6. The amount of tax payable disputed. 7. The grounds of appeal. Note that the grounds of appeal may not be different from the grounds of objection. Section 2.2. Establishment of a tax appeal tribunal. The Tax Appeal Tribunal was established by Section 59 subsection 1 of the Federal Inland Revenue Service Establishment Act 2007 as provided for in the 5th schedule to the Act. Power of the Minister. According to the Act, the Minister may, by notice in the Federal Gazette, specify the number of zones, matters, and places in relation to which the Tribunal may exercise jurisdiction. Composition of the Tribunal. The Tribunal shall consist of 5 members, hereinafter referred to as Tax Appeal Commissioners, to be appointed by the Minister. Appointment and meeting of the Tribunal. A chairman for each zone shall be a legal practitioner who has been so qualified to practice for a period of not less than 15 years with cognate experience in tax matters. B. A chairman shall preside at every sitting at the Tribunal, and in his absence the member shall appoint one of them as the chairman. E. The quorum at any sitting of the Tribunal shall be 3 members. D. A person shall not be qualified for appointment as a tax appeal commissioner unless he is knowledgeable in the laws, regulations, norms, practices, and operations of taxation in Nigeria, as well as persons that have shown capacity in the management of trade or business, or a retired public servant in tax administration. E. A tax appeal commissioner shall hold office for a term of 3 years, renewable for another term of 3 years only, and no more, from the date on which he assumes his office or until he attains the age of 70 years, whichever is earlier. F. A tax appeal commissioner may, by notice in writing under his hand addressed to the Minister, resign his office, provided that the tax appeal commissioner shall, unless he is permitted by the Minister to relinquish his office sooner, continue to hold office until the expiry of 3 months from the date of receipt of such notice, or until a person duly appointed as his successor assumes his office, or until the expiry of his term of office, whichever is earlier. G. A tax appeal commissioner may be removed from office by the Minister on the grounds of gross misconduct or incapacity after due inquiry has been made and the tax appeal commissioner concerned has been informed of the reasons for his removal and given an opportunity of being heard in respect of the reasons. H. The salary and allowances payable to and the terms of conditions of service of the tax appeal commissioner shall be determined by the Revenue Mobilization Allowance and Fiscal Commission, and shall be prescribed in their letters of appointment, provided that neither the salary and allowances nor the other terms and conditions of service of a tax appeal commissioner shall be varied to his disadvantage after appointment. I. If for any reason other than temporary absence any vacancy occurs in the office of a tax appeal commissioner, then the Minister shall appoint another person in accordance with the provision of this Act to fill the vacancy. Constitution of a Tribunal. The question as to the validity of the appointment of any person as a tax appeal commissioner shall not be the cause of any litigation in any court or tribunal, The constitution of a tribunal. The question as to the validity of the appointment of any person as a tax appeal commissioner shall not be the cause of any litigation in any court or tribunal, and no act or proceedings before the tribunal shall be called into question in any manner on the ground merely of any defect in the constitution of the tribunal. Appointment of the secretary to the tribunal. A. The minister shall appoint for each place or zone where the tribunal is to exercise jurisdiction a secretary who shall 1. Subject to the general control of the tax appeal commissioners, be responsible for keeping records of the proceedings of the tribunal. 2. Be the head of the secretariat and responsible for the day-to-day administration. And 3. Be responsible for the direction and control of all other employees of the tribunal. B. The official address of the secretary appointed for each zone shall be published in the Federal Gazette. Appointment of other staff of the tribunal. A. The minister shall appoint such other employees as he may deem necessary for the efficient performance of the functions of the tribunal, and the remuneration of persons so employed shall be determined by the National Salaries and Wages Commission. B. The employment in the tribunal shall be subject to the provisions of the Pension Reform Act, and accordingly, officers and employees of the service shall be entitled to pensions and other retirement benefits as are prescribed under the Pension Reform Act. Jurisdiction of the tribunal. The tribunal shall have power to adjudicate on disputes and controversies arising from the following tax laws, hereinafter referred to as the tax laws. 1. The Companies Income Tax. 2. Personal Income Tax Act. 3. Petroleum Profit Tax Act. 4. Value Added Tax Act. 5. Capital Gain Tax Act. 6. Any other law contained in or specified in the first schedule to the Act, or other laws made or to be made from time to time by the National Assembly. B. The tribunal shall apply such provisions of the tax laws referred to above as may be applicable in the determination or resolution of any dispute or controversy before it. Criminal prosecution. Where in the course of its adjudication, the tribunal discovers evidence of possible criminality, the tribunal shall be obliged to pass such information to the appropriate criminal prosecuting authorities, such as the Office of the Attorney General of the Federation or the Attorney General of any state of the Federation, or any relevant law enforcement agency. Appeals to the tribunal. Notice of appeal. A notice of appeal against an assessment shall specify the following particulars. A. The official number of the assessment, the date and the year for which it was made. B. The amount of total profit on which the tax was charged. C. The amount of the tax charged. D. The date of service of notice of refusal by the Revenue Service to amend the assessment. E. The precise grounds of appeal against the assessment. This must be the same as the grounds stated in the notice of objection to the Revenue Service. And F. Address for service of any notice, correspondence or other documents to be given to the appellant by the Secretary of the Appeal Commissioners. All notices, documents, or correspondences to be given to the Appeal Commissioners shall be addressed to the Secretary to the Appeal Commissioners in writing before the hearing of the appeal. A company may discontinue any appeal by it on giving notice in writing to the Secretary to the Appeal Commissioner at any time before the hearing of such appeal. Notwithstanding that a company has given notice of appeal against an assessment, the Revenue Service may revise the assessment in agreement with the company. The Revenue Service shall give notice of such agreement in writing to the Secretary to the Appeal Commissioner at any time before the hearing of the appeal, and such appeal shall be discontinued. Notice of refusal to amend. When a notice of refusal to amend has been received by any company, the company, if it desires, can appeal against the assessment upon given notice, that is, notice of appeal in writing to the Secretary of the Tax Appeal Tribunal within 30 days from the date of service of the notice of refusal. The date of service is the date on the notice of refusal to amend, and not the date of receipt of the notice by the company. A late appeal may be accepted upon an application being made to the Tax Appeal Tribunal if there is reasonable excuse for the delay, for example, postal delays. Appeals from decisions of the service, FIRS. A person aggrieved by an assessment or demand notice made upon him by the service, or aggrieved by any action or decision of the service under the provision of the tax laws referred to in paragraph 4.3a above, may appeal against such decision or assessment or demand notice within 30 days of the service of the notice of assessment. B. An appeal under this schedule shall be filed within a period of 30 days from the date on which a copy of the order or decision which is being appealed against is made, or deemed to have been made by the service, and it shall be in such form and be accompanied by such fee as may be prescribed, provided that the tribunal may entertain an appeal after the expiry of the said period of 30 days, if it is satisfied that there was sufficient cause for the delay. C. Where a notice of appeal is not given by the appellant as required under A above, within the period specified, the assessment or demand notice shall become final and conclusive, and the service may charge interest and penalties in addition to recovering the outstanding tax liability which remain unpaid from any person through proceedings at the tribunal. Appeals by the service. Service aggrieved by the non-compliance by a person in respect of any provision of the tax laws, it may appeal to the tribunal where the person is resident, giving notice in writing through the secretary to the appropriate zone of the tribunal. Procedure before Tax Appeal Tribunal. A. As often as may be necessary, Tax Appeal Commissioners shall meet to hear appeals in the jurisdiction or zone assigned to that tribunal. B. Where a tax appeal commissioner has a direct or indirect financial interest in any appeal pending before the tribunal, or where the taxpayer is or was a client of that tax appeal commissioner in his professional capacity, he shall declare such interest to the other tax appeal commissioners and refrain from sitting in any meeting for the hearing of that appeal. C. The Secretary to the Tribunal shall give 7 clear days' notice to the service and to the appellant of the date and place fixed for the hearing of each appeal, except in respect of any adjourned hearing for which the Tax Appeal Commissioner have fixed a date at their previous hearing. D. All notice, documents other than decision of the tribunal may be signified under the hand of the Secretary. E. All appeals before the Tax Appeal Commissioners shall be held in public. F. The honors of proving that the assessment complained of is excessive shall be on the appellant. G. At the hearing of any appeal, if the representative of the service proves to the satisfaction of the tribunal hearing the appeal in the first instance that 1. The appellant as for the year of assessment concerned failed to prepare and deliver to the service returns required to be furnished under the relevant provisions of the tax laws mentioned in 4.3a above. 2. The appeal is frivolous or vexatious or is an abuse of the appeal process. Or 3. It is expedient to require the appellant to pay an amount as security for prosecuting the appeal. The tribunal may adjourn the hearing of the appeal to any subsequent day and order the appellant to deposit with the service before the day of the adjourned hearing an amount on account of the tax charged by the assessment under appeal equal to the tax charged upon the appellant for the preceding year of assessment, or 1/2 of the tax charged by the assessment under appeal, whichever is the lesser, plus a sum equal to 10% of the said deposit, and if the appellant fails to comply with the order, the assessment against which he has appealed shall be confirmed, and the appellant shall have no further right of appeal with respect to that assessment. H. The tribunal may, after giving the parties an opportunity of being heard, confirm, reduce, increase, or annul the assessment, or make any such order as it deems fit. I. Every decision of the tribunal shall be recorded in writing by the chairman, and subject to the provision of paragraph 16, a certified copy of such decision shall be supplied to the appellant or the service by the Secretary upon a request made within 30 days of such decision. J. Where upon the hearing of an appeal, no accounts, books, or records relating to profits were produced by or on behalf of the appellant, such accounts, books or records were so produced but rejected by the tribunal on the ground that it had been shown to his satisfaction that they were incomplete or unsatisfactory. The appellant or his representative at the hearing of the appeal has neglected or refused to comply with a notice delivered or sent to him by the Secretary to the tribunal without showing any reasonable cause, or the appellant or any person employed, whether confidentially or otherwise, by the appellant or his agent, other than his legal practitioner or accountant acting for him in connection with his ability to tax has refused to answer any question put to him by the tribunal without showing any reasonable cause. The chairman of the tribunal shall record particulars of the same in his written decision. Procedure following decision of the tribunal. Notice A. Notice of the amount of the tax chargeable under the assessment as determined by the tribunal shall be served by the service upon the taxpayer or upon the person in whose name such taxpayer is chargeable. B. An award or judgment of the tribunal shall be enforced as if it were a judgment of the Federal High Court upon registration of a copy of such award or judgment with Chief Registrar of the Federal High Court by the party seeking to